हेलो दोस्तों, आज हम लेने वाले हैं 120 वर्ड पर मिनट इंग्लिश लीगल डिक्टेशन। बी रेडी फॉर इट। 10 सेकेंड, 5 सेकेंड, start. Paragraph. Gentlemen of the jury, it now becomes the duty of the court to instruct you as to the law governing this case, and what I shall say to you on that subject you must be governed by. The court presides at the trial of an action for the purposes of, among other things, determining the law in the case and advising the jury as to what the law of the case is, and also passing upon objections to evidence which may be offered in support of the issues joined, and seeing that improper evidence is excluded for the jury's consideration, so that they may readily see the issues and apply the evidence that is adduced in support of the issues, or to contradict the issues. The jury are the judges of the facts, and with the jury rests the determination of what the facts in issue are. It is peculiarly the province of the jury to determine from the evidence and the natural and logical inference to be drawn from the evidence what the facts involved in the case are, and by their verdict and determined the facts, and with their finding the court has nothing to do except, as I have theretofore said, to see that they are properly instructed and only consider proper evidence. Paragraph. If the court, in making any ruling during the trial of this case, has said anything from which the jury infers that the court has any option as to how this case ought to be decided, I now charge you to disregard what the court said in that behalf. I have no recollection of having said anything of that nature, but out of an abundance of caution, I now say to you that it is your duty to exercise that independent judgment upon the evidence in the light of these instructions, and by your verdict determine what the facts in issue are. Paragraph. A fact is said to be in issue when it is asserted on one side and denied on the other, and the facts in issue are to be found in the pleadings in the case. There is a common error which calls arguments of counsel to the jury before the close of the evidence. The pleadings of counsel that is incorrect. Those statements made by counsel to the jury in explanation of the evidence and in behalf of their respective contentions are the arguments of counsel, while the pleadings are the written statement of the parties to the action filed in the action before it is submitted to the jury, and contain the facts which each claims exist in the case. Paragraph. In this action, Sable and his younger brother Thomas are the plaintiffs, and John William Glens is the defendant, and the pleadings in this case consist of the petition, the answer thereto, and the amendment to the answer, and a reply to the amendment to the answer.